Welcome back to Journey to Justice, the channel where we turn dusty law cases into stories you actually remember. Today, we are diving into the absolute classic, Younes v. Chrysanthou from 2016. This is the case that asks the million-pound question: if you call your mate my business partner for years, does the court actually agree when the money's on the line? Picture this relatable nightmare. Two businessmen, let's call them Ahmed and George for the story. They have been hustling together since the early 2000s, doing property deals, flipping investments, the whole startup vibe. Ahmed is wiring George cash. George hands Ahmed handwritten notes about a 70/30th profit split. They are high-fiving at meetings, and everyone around them calls them the partners. Fast forward to 2016, a deal goes big, and Ahmed says, "Mate, we've been partners since 2003, where's my cut of all these profits?" George is like, "What? We never agreed that." Now the high court has to untangle this entire mess. Ahmed brings everything he has: texts, old emails, witnesses saying yeah they were partners, even some dodgy-looking receipts. But here is where it gets juicy. The judge is not impressed. The court says, hold on. Just because you throw around the word partner like confetti doesn't make it legally true. They want proof. A proper agreement, consistent behavior showing they ran a business in common, shared risks and profits properly, and acted as each other's agents. Those vague "I think we said this 12 years ago" stories, the judge calls them unreliable. Witnesses saying they seemed like partners. Nice try, but not enough. Think about your own life for a second. You and your uni mate start a little side hustle selling custom phone cases. You split costs, call each other business partners on Instagram, and split the first £200 of profit. 3 years later, when your Etsy shop blows up, does the law automatically say you're partners with unlimited liability? Younes says nope. The court puts the burden square on Ahmed. Prove this partnership existed. He couldn't. Case dismissed. Your exam gold here is crystal clear. Mere descriptions as partners are insufficient without evidence of an actual partnership relationship. Problem questions. Love this trap. Someone always claims, but everyone called us partners. You can slam them with Younes. Labels are social media vibes, not legal contracts. And here is a real-life warning. Next time you are texting about that podcast idea with your mate, maybe get a quick agreement saying this is not a partnership unless we say so. Because courts do not mess around when unlimited liability is at stake. If that made partnership law finally click for you, smash that like button, comment labels equals nope, and subscribe for our full partnership crash course. This is Journey to Justice, signing off.